the things we're going to try to do is to sort of identify the, I'll call it the ethical underpinnings of some legal rules that govern our practice. So let's launch in here. We're doing this in conjunction with Niagara Health again, and we're happy to have that partnership. This is land acknowledgement that is grounded. We're in London, so this is a London, Ontario-based land acknowledgement. So we acknowledge that we're gathered today on the traditional lands of the Anishinaabe, the Haudenosaunee, the Lenape, and the Attawandaron. We acknowledge all the treaties that are specific to this area. This land continues to be home to diverse Indigenous people, First Nations, Métis and Inuit, whom we recognise as contemporary stewards of the land and vital contributors to society. This land acknowledgement is intended as a step towards reconciliation. Awareness means nothing without action. It is important that everyone takes the necessary steps towards decolonising practices. We encourage everyone to be informed about the traditional lands, treaties, history and cultures of the Indigenous people local to our region. So we do want this to be more than just words. It's an acknowledgement that we operate in a very particular location. We have no conflict, so Lockie and I are going to be presenting today. Give us a wave, Lockie. Now, for those of you that have not met Lockie, you may detect a similarity in surname. I'm happy to be working with one of my sons here. It's a pleasure. Lockie is completing his PhD in ethics, writing on medical aid in dying and its extension to people who solely have a mental health condition. That's at Carleton University, and he's currently working with LHSC as an intern in their ethics program. So, and it's a pleasure to work with him. So today we're going to look at it. This was prompted by a puzzle about the phrase that occurs at the beginning of, I think, all of the acts that govern, or the principal elements that govern the practice of healthcare, consent and in particular. There's this little phrase at the beginning that uses the words common law duty to restrain or confine. And they just sort of float there. And what we wanted to try to do is to connect those to the concepts that are sort of related to them. So picking up the word duty, we're going to talk a bit about the duty to care, because I think often these duties get conflated. So we want to try and unpack some of those. We then want to unpack the ethical underpinnings of those duties. So where do they come from? And then talk about the implications for practice. We thought we should put flashing lights with this. We are not lawyers. This is not legal advice. Can you nod to get? Do not take this as legal advice. What we're going to try and do is look at the ethical pieces that we think are sort of sitting behind that. So here's the basic problem. We're free unless we're not. So I don't know how to put that any other way, or any more bluntly. It is a fundamental assumption of who we are, where we are, the ways in which we get to live our lives, the sorts of things that we think of ourselves as persons. And that's the idea that you get excuse me, you get, I get, we all of us get to live our lives as we see fit. We are free to do whatever we like, unless we're not. And the entire discussion today is around that, unless we're not. What are the justifiable conditions for interfering with, restricting my liberty, my freedom? I think somebody's got an unmute, or somebody's not muted and they're shuffling papers. So if you could just check that you're muted. Thank you. So step one, we're free unless we're not. Step two is, okay, so what's not? What are the ethical justifications for restricting someone's freedom? And then we're going to unpack those ethical justifications in terms of the law that they give rise to. So how ethics becomes law, part one, thinking about battery and forcible confinement. How ethics becomes law, part two, the duty to restrain and confine. Then we'll take a little aside and talk a bit about duties, in particular duties that arise in the healthcare context, so duties to provide care and duties to care. So it's one word different, but they're really quite different ideas. And then we'll go to how ethics becomes law, part three, and there we'll look more directly at the Healthcare Consent Act and the Patient Restraints Minimisation Act. And of course, we'll talk about the puzzles and the challenges that run through all of that. So let me start with a story. The problem with stories is that they work well when they're really detailed. And the problem with stories is that if they're really detailed, we may end up sharing too much. So I'm going to try and steer a line. This is a real story, concerns a real person and a real family, and it crops up in a real organization. But I'm going to try and sort of fuzzy it up a little bit so that we can't move directly to the person. It concerns a patient. Let's have him in his 70s, maybe even put him in his later 70s. He has some dementia. So the beginnings of dementia. That means that he's not as sharp as he used to be. I think I'm trying to put this in a way that is not too technical, because I don't think the technical pieces give us the answer. And he's less able to control his impulses. He sort of has an idea and he goes off and pursues his idea. Well, in this case, his idea was that he wanted to go to Florida. This was before everybody has decided that they refuse to cross the border ever again. So let's situate this a little while ago. He wanted to go to Florida. So he wanted his wife to go with him, but she didn't want to, was not able to do that. She was recovering from a medical intervention that she'd had, and she wasn't prepared to go. So he went by himself, got in his car, drove to Florida. Now, there were some bumps on the road. I think the car broke down and he had to try to work out how to repair it. And it turned out that the accommodation he thought he had, he didn't have, and he ended up sleeping in the car for a bit. And eventually got picked up by a local police department, admitted to a hospital there, and it was determined that he should go back home. So his family flew down, got him, brought him back home, and the family, because they were concerned about the things that he might be doing, confiscated his passport. Well, what do you do if your passport's stolen? Yeah, you see different ways of describing things, right? He wanted to renew his passport, so he went and reported the passport gone. Went through the process of getting another passport perfectly successfully. A bit of a bump in the road. He thought he would camp out in the parking lot of the passport office for a couple of days, waiting for the passport to arrive, but. Yeah, he got through that. Picked up his passport. Went to the airport in Toronto. Took another flight to Florida. He was prepared. He took with him, his car had been impounded, so he took his license plate down and a screwdriver so he could put it back. Go on, I'm seeing some smiles. He got picked up again and returned and found himself in the hospital, and that was the consult. He had a previous history of an assault against his first wife. Lived with his second wife for decades. She was anticipating, he could be volatile, but she had a safety plan. And then, partway through that, and the consult included the physician, psychiatry from that hospital. And then the physician said, "We're holding him under a duty to care." So go on. I'm going to ask, what do you think? And let me leave aside whether we use the language of a duty to care, and whether that may be connected to a duty to restrain and confine. Maybe. Let me do, and we're going to post this as a poll. I think you're going to ask, should we hold this guy? Okay, so really, I think you're launching the poll there, and I think so. We'll see as the results come in. Lockie, you'll watch the chat, and or maybe I'll watch the chat because it might be that I'm switching to your bits soon. What did I say? 12. No, I've got a couple more. So this comes back to that basic problem. I'm going to answer the poll. Comes back to that basic problem. We're free unless we're not. Do we have grounds to hold this person who manifestly does not want to be here, doesn't want to be in the hospital, doesn't even want to be in the province? So I'm posing this question in terms of restraints, because the next piece is, if you hold somebody, you've got to work out how you're going to hold them. So what method do you have of actually keeping that person? So we're free unless we're not. Restraints are bad, but sometimes they're less bad than the alternative. So how do we go about deciding what's appropriate under those circumstances? I just got an echo of it. Did that go? Are we okay? Sounds all right? Okay. So this is that restraint's a bad idea, or confinement is bad. It's the same idea. I want to try and defend the idea, that basic assumption, that an essential part of our sense of self is our ability to move around, our freedom of movement. A restraint can be, the legislation talks about it in different terms: physical, chemical, or environmental. But what a restraint does, its function is to take away my capacity, take away my ability to move around. And I really want to, I want to say this is a big deal. Restraint is a limit on who I am as a person, and it's imposed from the outside. That's the crucial piece. It's somebody else is saying, no, you can't do that. Somebody is making a deliberate decision or attempt to restrict my freedom. So, Lockie, are we going to you here?
Yeah,
I think we are. Okay, go.
Yeah. So something that we're going to be highlighting a lot here is, again, restraints are bad. They come with a harm to the person that's being restrained. But sometimes, in particular circumstances, it is less bad to restrain them. So there are some ethical justifications for restraining in some circumstances. One such justification, in my opinion, the strongest justification, is to prevent harm to others. So Rob was busily mentioning that a fundamental aspect of who we are as people, as human beings, is that we are autonomous and that we can govern our own lives and choose to live it as we see fit. And that justifies not interfering with individuals, right? However, what happens if I use my ability to be free, to be self-governing, to harm other people? Well, now I'm using my freedom to impinge upon or infringe upon the freedom of others. And so one strong justification for the use of restraint is to prevent harm to others. And this is sort of captured in the saying that your right to swing your fist stops at my face. Okay. And so you do have the right to be free. However, you're not free to impinge upon the freedom of others. And so we have a strong justification for restraining an individual when they are harming or have a strong threat of harming someone else. Next slide. Now, another interesting justification for the use of restraint is to prevent harm to the individual that is being restrained. And so this is where we restrain an individual to prevent them from harming themselves. But this is much trickier than the example of one person harming another, because who gets to determine what constitutes a harm, and what counts as a harm to self? So when can we step in and restrain an individual with the reasoning of, we need to do so to protect you from yourself? A really obvious example might be, say, an individual suffering from an acute mental health crisis in the hospital that is threatening to take their own life. Okay, it seems like there's strong justification to step in there. But there are other circumstances where there might be this harm to self that doesn't seem strong enough for us to interfere. So we do have to do some navigating there, and it's really important. So this leads us to how ethics becomes law. So again, we're going to come back to this idea that restraints are harmful to the individual being restrained. And this is captured in law. So battery is a concept that is frequently used and applied in tort law. So tort law is civil law, so not criminal. And the tort of battery is committed whenever someone intentionally applies unlawful force to the body of another. And there must be something about that contact that is physically harmful or offensive. So again, the idea, people are fundamentally free, ability to self-govern. I have sovereignty over my own body. Therefore, other people aren't allowed to touch me. Okay. And so battery captures that idea, but specifies that unlawful force cannot be applied to me, and it must be harmful or offensive. So that means you could tap me on the shoulder, that's fine, but you can't push me, you can't shove me, right? You can't do something that would harm me. However, as healthcare providers, you'll be touching, poking, prodding people all the time. And so what justifies this? And again, this really enshrines the concept of consent. So I am self-governing. I have autonomy over my own body. You can't touch me unless I give you permission to do so, right? So this is an extension of my will that allows you to come into contact with me when normally you would not be permitted to do so. So you do so without my permission and it's harmful, that could constitute battery. Now there's also the concept of confinement, which is false imprisonment or forcible confinement. And we have an excerpt here from a court case to sort of define what is meant by confinement. So this is a total physical constraint contrary to the wishes of the person restrained, but to which the victim submits unwillingly, thereby depriving the person of his or her liberty to move from one place to another. So if you were to confine someone unlawfully, you would violate the criminal code of forcible confinement, which is defined here at the bottom as well, to confine without lawful authority or prison or forcibly seize another person. So again, applying force to another person via restraint or detaining or confining is a harm, and that is reflected in the law here, that if it is done unlawfully or inappropriately, comes with legal ramifications. However, there are some circumstances where it's appropriate to intervene, right? This is the circumstances of protecting someone else from an individual or protecting an individual from themselves. And so what comes up in loads of the healthcare related legislation is the common law duty to restrain or confine. So the common law duty to restrain or confine is when an immediate action is necessary to prevent serious bodily harm to the person or to others. And this is referenced in the Fixing Long-Term Care Act, the Healthcare Consent Act, the Mental Health Act, the Substance Decisions Act, and the Restraint Minimization Act. So all of these acts near the beginning say, interestingly, nothing in this act affects the common law duty of a caregiver to restrain or confine a person when immediate action is necessary to prevent harm. So there's this strong primacy to the idea of this duty to restrain or confine to prevent harm. However, there are some complications in when this might apply.
So is it my turn? I think it's my
Yeah.
turn. So it follows the steps through this. We're free unless we're not. Okay, that means we need to understand the justification for interfering with my freedom, prevent harm to self, prevent harm to others. Good. That gets enshrined in law. And it gets enshrined in law in a couple of different ways. The however, though, is that in order to enforce that idea, to enforce the idea that I can't harm others in particular, or maybe can't harm myself, we get that common law piece, which turns into a duty that applies to, in this case, healthcare providers. So the duty is to provide immediate action to prevent serious risk of harm to self or to others. Now we can get to the puzzles. The first one is that often when we're thinking about uh, the application of a restraint or confinement, the restriction of somebody's freedoms, we'll often be thinking about whether or not the person has got the capacity to make their own decisions, whether they're capable of consenting under the auspices of the Healthcare Consent Act. But if there's a common law duty to restrain or confine, that I think acts completely independently of whether the person is capable. So it doesn't matter if there's a common law duty to restrain and confine, whether the person is intentionally, deliberately understands what they're doing. The duty is to stop them from doing it, because either because it's going to harm others or because it's going to harm themselves. So here are the puzzles that are associated with that. What does immediate mean? So go back to our first story. Did we get answers from our first I should look in the chat because it's probably in the chat, isn't it? Let me have a look. Let me turn the chat on. I've got to view the poll. Give me a minute.
90% of people said no. 10% said yes.
Okay, fine, good, thank you. Now, so people are moving in one direction, but at least there is some discussion about this. So, and you can think through where this discussion lies. I think in all of the conversations that we're having today, there are going to be a whole series of situations where what's required is a judgment, a decision that this applies more than that, where we could go one way, we could go the other way, but on balance, we're going to go in this direction because. And I think what we're trying to explore is what the constituent elements of those judgments might be. So in that duty to restrain or confine, what counts as immediate? So you can start thinking about examples. The guy who is going to leave the emergency department and drive home, but the person is intoxicated. Do you have an obligation to stop them, or is there an obligation, to physically stop them, or is there an obligation to notify law enforcement, or whatever? You're okay with the questions of judgment here. So what counts as immediate? What counts as necessary? So what is required, the thing that we have to do? And then the condition is serious bodily harm. So it's bodily, and it's a harm, and it's a serious harm. So in all of those, I think there are challenges, issues, questions of judgment. So go on, over to you. You must have experiences of this. Do you want to throw into the chat the idea that an example where you or your team has acted immediately to stop somebody, to restrain or confine in order to prevent serious bodily harm either to the self or to another. I just want to pick up a comment in the chat. Look at this. So this is from Stephen. The concept that if you act in good faith, you're protected from civil liability. I'm going to find the phrase. There is a phrase that covers that in the Healthcare Consent Act. So I'll have to go and find it. Now, training and responsibility. and not merely transient or trifling as the conditions for harm. So thank you for the comments in the chat. And now we're getting some coming in about the duty to restrain and confine. Examples of that, you might want to just to have a look at those. All right, let's keep going. So we're going to make a slight shift. We were talking about duty to restrain and confine. We're going to talk more broadly about duties, because when people sort of think their way through this, they might invoke the duty and maybe not differentiate between the different types of duty that we all of us fall under. So a duty entails an obligation. So that means I've got to do it, either to act or not to act. They're often associated with a role. So there are duties that come with the particular role that we might be playing. We're talking about duties that particularly apply to healthcare providers. And I want to talk about two. I want to talk about the duty to provide care and the duty of care. Now, it's only one word different, but they're really different ideas, and I want to separate them out. So the duty to provide care idea, that was really prominent through COVID. So if you think back, there were all sorts of discussions about what the obligation was on a healthcare provider to show up for work, the obligation to provide care, even under conditions of personal risk. It was a topic of much debate about the appropriate level of personal protective equipment and so on. But the idea behind it was the idea that in taking on the role of a healthcare provider, so in taking on the role of a physician, in taking on the role of a nurse, you have made a commitment to your community that entails obligations that flow back to you. And those obligations that flow back are something like the duty to provide care, even under conditions of personal risk. Ton of questions about how great that risk might be, ton of questions about mitigation of risk, but the general idea is that the duty to provide care, that idea is that because we take on particular roles, we take on duties, and the role of the healthcare provider entails that duty to provide care. Now that often gets, I'm using the word conflated here, run into the duty of care, which is different, quite different. So the duty of care, again, it's one of those bigger legal ideas. It is applicable not just in healthcare. It's applicable generally. It's the idea that people should take reasonable care to avoid acts or omissions that you could reasonably foresee would harm your neighbor. And then all of the debates in law, many of the debates in law, are about what counts as your neighbor. In the healthcare environment, the care relationship, the relationship of physician to patient, or of a nurse to patient, or of a healthcare provider to patient or clients, creates a duty of care to that individual. So in a way, what's happening there is that the healthcare roles are what creates the relationship of neighbor, the connectedness. So that turns into a duty of care between between a physician and patient, nurse and patient, other healthcare provider and patient. Now, what does that mean? And it's the next move is to connect a duty of care to the notion of standards of care. So one way of thinking about what the duty to care entails is to ask what happens when we fail in our duty of care. So this is from the CMPA, the Physicians Medical and Protective Association. They define or unpack this duty of care idea in terms of what happens when it fails. So to determine whether physicians have breached their duty of care towards a patient, the courts rely on the standard of care, which is defined by the degree of care and skill that could reasonably be expected of a normal prudent practitioner of that same experience and standing. So it's not an ideal standard, it's a practical standard. The standard of care is what we would reasonably expect of a physician, a care provider of that type in that situation. So how do they come together? How do those issues of the standard of care and the duty to care come together? I can't remember if you were going to talk about this one or if I was, Lockie. I'll do it now that I'm in it, and then maybe I'll switch to you for the next one. So this will be a conversation that you're all familiar with. Should a physician discharge a patient out to the community, a patient who is known to be an intravenous drug user, should a physician discharge a patient under those conditions, somebody who needs intravenous antibiotics, often for something like endocarditis, should that person be discharged into the community with their PICC line attached? Go on, give me a nod if that is a feature of your experience. I've only got two people who I can see, so I don't know. I'm assuming that the two people I can see often. There you go. Thank you. I think this is a really common challenge, and it's a challenge that physicians have grappled with for at least the last 10 years, I would say. So you know how this works, right? The gold standard treatment would be that intravenous antibiotic, so delivered via a PICC line. If the patient is not known to be an intravenous drug user, they could be discharged and I could have that treatment in the community. But if they are known to be an intravenous drug user, then there is the possibility that the patient will use that method of injection of drugs and can overdose. And so the question is, does a discharge fit within the standard of care? Are you okay with the question? To put it a different way, what does the good physician do? And that turns into a whole series of questions about what the standard of care might be. Now, I just found this article the other day. It asked the question really neatly. Can I safely discharge a patient with a substance use disorder home with a PICC? So this forms, it's the New England Journal of Medicine. It actually quotes an article that came from LHSC from London maybe 4 or 5 years ago. I'm not going to try and shape clinical judgment, but if this is an area that has cropped up in your practice, you might want to have a look at this and share it with the healthcare teams that you're working with, trying to keep patients in the hospital in order for them to go through that typically 6-week or so course of treatment is a nightmare, profoundly difficult. So what will often happen is in these conversations, somebody will say, no, I cannot discharge the patient with that PICC line intact because that is contrary to my duty of care. And that's often connected to an idea that it would be contrary to the standard of care to discharge a patient under those circumstances. Does that make sense? Are you okay with the challenges there? Now I've got Stephen. Yeah, I know which side you're falling on, Stephen. And this is part of a significant ongoing conversation. So maybe it underlies the entire conversation. Under what circumstances should we, as a community, you as healthcare providers, intervene in a person's freedom to stop them from doing things that they want to do, even if those things are manifestly self-destructive? So, yeah, I think we're in the middle of a I don't know, big debate. Lockie, I think this is you.
Yeah. Okay, so we've been busily talking about how restraints are harmful. In some circumstances, they are permissible. So what outlines the circumstances in which use of restraint is permissible. So we already mentioned the common law duty to restrain or confine. And I want to highlight that there is primacy to that. So all the legislation that I am about to talk about, each one of them includes a section saying this does not affect the common law duty to restrain or confine. So this is all in the context of that common law duty. So this is just extra circumstances in which we could apply restraint outside of that common law duty. So I have a really big block of text here. Don't worry, I'm not going to just read this out to you, but this is from the Patient Restraints Minimization Act. I think it's just often useful to have the exact language available so you can see what it means. But I'm going to summarize it in on the next slide here, Rob, if you don't mind moving it forward. And I'm hoping that either the slides or that content will be made available so you can read it directly when you have more time. But in essence, what the Patient Restraints Minimization Act does is outline when restraints can be used under the Healthcare Consent Act and the Substance Decisions Act and the Fixing Long-Term Care Act. So it does not apply to the Mental Health Act. So we'll go into the Mental Health Act next, right after this. So the rules of the Patient Restraint Minimization Act do not apply to the Mental Health Act. So what does the Patient Restraints Minimization Act say? It says restraints are prohibited unless, so again, restraints are harmful. So in general, they're not allowed. They're only allowed in particular circumstances. So restraints are prohibited unless they are used to prevent serious bodily harm to self or other. They give greater freedom or greater enjoyment of life. They are authorized as part of a plan of treatment with consent of patient or substitute decision maker, or as prescribed by regulation. So again, we're highlighting the important ethical justification here of harm to self or others. This adds in the greater freedom or greater enjoyment of life. It might sound a bit counterintuitive to talk about how restraints can improve freedom or enjoyment of life. An example that I think is useful are the trays that are put on chairs that prevent individuals from falling out. That's a form of restraint, but it might allow them to get out of bed and socialize in the hospital or in long-term care home, wherever they may be. So it is a form of restraint, but it gives them greater freedom in another way. According to the Patient Restraint Minimization Act, every organization must have a policy which outlines the use of restraints. So we have people from a variety of different organizations that are here in on this call. Each one of your organizations will have a policy that specifically outlines the context in which restraints can be used. And typically these just provide an interpretation of what is said in the Patient Restraint Minimization Act. So I encourage you to look at your organization's policy on restraint. On top of this, restraint requires an order. So a physician must put in an order for the use of restraint. Patient must be monitored. So you can't just put someone in restraints and then walk away and leave them. You must monitor them while they are restrained. And staff must be trained on how to safely and effectively use restraints. Okay, so the Mental Health Act. So as mentioned, all the stuff from the Patient Restraint Minimization Act does not apply to the Mental Health Act. And the Mental Health Act specifically outlines the context in which individuals can be forcibly detained and provided treatment in a hospital for a mental disorder. So in order for an individual to be detained in hospital, they would first need to be subjected to a Form 1. This is an application for assessment, and they have to meet what are called Box A and Box B criteria. In general, the criteria are that a person is at risk of harm to self or others, or physical impairment, with there being evidence of a mental disorder causing that risk. So this is, again, obviously, because we're talking about the Mental Health Act, same concept of risk of harm to self or others. If a physician, and this could be any physician, believes that a patient is suffering from a mental disorder that would cause them to be at risk of harm to self or others, they can complete a Form 1, and that allows that person to be detained in hospital for up to 72 hours until they can be assessed to determine whether or not they do in fact have a mental disorder that is leading to this risk. If upon assessment, it is deemed that they do have a mental disorder that is leading to this risk that would benefit from being hospitalized, they can then be subjected to a Form 3, which detains them in hospital for up to 2 weeks in order to receive treatment. And if they still require treatment after that, Form 4 could be filled out to renew the treatment for another 4 weeks. So the idea here is that if someone is suffering from a mental disorder, that would lead to them potentially suffering risk of harm to self or to others. We can hold them in the hospital, the idea being that they're not capable of consenting to their mental health treatment, and we can provide them treatment. And then once they're able to, they're no longer at risk and their mental health disorder has been treated to the point where it's safe to release them, they would then be released. And if restraint is used while they are admitted to the hospital, it must be clearly documented in the patient's record, and a statement must be made as to how the restraints were used and why they were used. Next slide, please. Now, the Mental Health Act has specific safeguards, because again, I'm going to be saying this a lot. Restraints are harmful. They can only be used in certain circumstances. So we really want to be careful as to when we're using them. So there are a few safeguards in the Mental Health Act that outline when individuals can be detained in hospital to receive treatment. And the first is they must be changed to an informal patient or to a voluntary patient as soon as possible. So what that means is after they've been in the hospital for a little bit as a formal patient, so involuntarily, but then they get to the point where they're capable of making decisions about their mental health care and they choose to remain in hospital, you must immediately lift the form and allow them to remain as a patient that is voluntary. If a patient is kept in hospital involuntarily, they must be provided rights advice as well. So what that means is if we are detaining someone in the hospital, they must be read their rights as to what recourses they can take. And that includes that the patient can challenge their involuntary status with the Consent and Capacity Board. So, Healthcare Consent Act. Restraint can be applied to an individual with the consent from the individual or the substitute decision maker. However, in the context of the Healthcare Consent Act, it must be couched within a broader treatment plan. So what this means is that restraint can be used as part of a broader treatment plan if there is consent from the individual themselves or a substitute decision maker. What is important here, particularly in the context of substitute decision makers, is that they don't get to dictate that restraints can be used whenever they like. It has to be in the context of a broader treatment plan, because again, the Healthcare Consent Act governs treatment. So this is restraint in the context of treatment. Next slide. So the Healthcare Consent Act is beholden to the Patient Restraint Minimization Act. So all of those criteria that I outlined for the use of restraint apply in the context of consenting to restraint as part of a treatment plan. And it also includes a specific criteria for when substitute decision makers can consent to the use of restraint. And it says the person shall not give consent on the recipient's behalf to the use of confinement, monitoring devices, or means of restraint unless the practice is essential to prevent serious bodily harm to the recipient or to others, or allows the recipient greater freedom or enjoyment. So again, we can use restraints, and there are very, very particular circumstances in which we can apply because restraints can be harmful. It's back to you, Rob. You're muted, sorry.
Yeah, I am. There you go. I just want to do another sentence on that last piece. When you think about seeking consent to a course of treatment from a substitute decision maker, I would defend the idea that if some form of restraint is going to be required in order to administer the treatment, then that should be a really significant feature of the consent discussion with the patient. So the feeding tube example is perhaps sort of an obvious one. The feeding tube might be inserted, but the patient has pulled it out. Maybe they've pulled it out more than once, and it's been reinserted. At some point, somebody will be saying, "Well, we need to strap them down. We need to hold their arms down so they can't pull the tube out." So then the question becomes, well, two questions. Should that feeding tube still be offered? And if it is still going to be offered, then the consent to that, to it being reinserted, must include the idea that the substitute decision maker is consenting to strapping the person down in order to continue the treatment. Okay, so it's not just a feeding tube; it's a feeding tube with restraint. Does that make sense? Because that's a puzzle, I think, about whether the treatment should be offered in the first place, and it's also a puzzle for the substitute decision maker about whether they should agree to it. Because it could be that the means of administering the treatment are so onerous that the treatment ought not to be administered. Does it sound okay? So anyway, it's one of the puzzles. So let's sort of keep picking those up. The capacity pieces, of course, it's always a puzzle. The Healthcare Consent Act uses the language of being able to understand and appreciate the nature of the decision that you have in front of you. The appreciate part is the bit that's difficult, because the temptation always is to say that if you don't agree with the treatment plan that's being offered by the healthcare team, then you're not capable because you don't appreciate the real significance of receiving that treatment. So that's a challenge. The substitute decision-making part is a real challenge. So if that incapable patient who needs treatment and wants to leave, what are the steps that we can take in order to prevent that? I think this stuff is really hard. I've got a recent story from a hospital in the region where the patient is a, relatively speaking, young person with autism spectrum disorder, probably doesn't need treatment in a hospital but has nowhere to live, and is unpredictably violent, wildly unpredictably violent, and ends up spending a massive amount of his time in restraints. That's a terrible situation. I don't know if I've got an answer, but the situation that person is living in is awful, which is why all of these discussions about the appropriate use of restraint and confinement are so heavy. These are weighty decisions. Many of you know I'm working in home care too. So what's the difference between expectations around restraint, confinement, and the application of a whole bunch of legal rules in an institutional environment? How does that work when the person's discharged home? So what are the expectations that govern the way in which a family deals with their loved one that they're caring for? And then notion of harm. So harm in this particular instance, so a physical harm in this particular instance, in the context of what might be the best version of a life that person may have available to them. So, specific harm, or are we working out what's good for this person as a person over a lifetime? And that's just trying to pick up that greater freedom and enjoyment of life idea. How does that apply when we're talking about the application of restraints? Now, those of you that we've worked with before, you know that I'm obsessed, puzzles about continuity of a life. What is it for one person to live one life through one lifetime? What makes me the same person now as the person that I might become in the future? So advanced directives used to be called Odysseus contracts. And the key idea is that the key puzzle is, can I bind myself in a decision now that'll have effect at some time later on? So Odysseus contracts, that's Odysseus. He's tied himself to the mast. He wants to hear the sirens sing. But of course, if you hear the sirens sing, then you immediately sail your ship off into the rocks and everybody dies. But he really wants to hear them sing. So he's bound to the mast. He's stopped the ears of all of his crew, and he's shouting to his crew, "Let me out! Let me go! I want to go and play." So can I literally bind you later to bind me? So can I tell my substitute decision maker, and through my substitute decision maker, the care providers that are that are looking after me, can I say bind me later? We've got a recent story of it's a hospital situation. The patient has dementia, and is mobile, and would frequently fall out of the bed, and crawl around on the floor in their room, and then if the door was open, be out crawling up and down the corridors. Now, that's not harmful, so not serious physical risk of harm. The family says, don't let her do that. Don't let her do that. That is undignified. And I'm deliberately using that is contrary to her sense of herself. And if she knew for 1 minute that she'd be crawling around on the floor, with people watching her, she would be mortified. Anybody who's worked in long-term care will have versions of that discussion where grandma appears in one of those fluffy, fleecy things with a hood, and the daughter says, "My mum would never be seen without her makeup. She would never wear a garment like that. You've got to dress her properly," because it's contrary to her notion of herself. So could I tell my care providers now, don't let me do things that would embarrass me? Restrain me, stop me from doing that. So we've just got some examples there of the things that I can do, and then puzzles about the things that I can't. And one of those puzzles, I think, would be around that notion of restraint. Can I? I'm looking at the chat. Negotiation and conversation. I'm going to say this directly to Stephen and maybe to all of you. In the real world, we're always trying to find a middle ground. We're trying to find a spot where we can have where there's agreement. I don't know, what am I going to call it? The philosophical world. I'm always looking at, well, okay, you've tried to find an agreement, but what are the limits on the agreement? What are the things we can't agree to? And that, I think, is sort of that those are the boundaries that we're trying to explore now. What are the limits on the possible things that we might agree to? And then we're still sort of just finishing up with the questions. At what point, under what circumstances, would not restraining somebody be viewed as contrary to the standard of care, and because of that, negligent? Similar puzzles about discharge. Yeah, look, I hope we've managed to convey that this entire topic is one that is profoundly challenging. Challenging not just for healthcare providers in the particular application of your relationships with your patients, but really challenging socially. Alberta, BC, one or other of those provinces has recently decided that they will require forcible treatment, so treatment against a person's will, for substance use disorders. Doug Ford has mused about the same idea. That's dramatic limitation of a person's choices in order to require them, to hold them in a healthcare facility in order for them to receive treatment. You could think about the ways this sort of turns puzzles about restraint and maybe coercion in the way in which ACT teams work. So a community treatment order, a CTO, requires somebody to receive treatment. And if they don't, then their freedom will be removed and they'll be brought in to have care. So I think all of these things are really challenging. I think all of them require judgment. I think the nuances of every situation are different. So let me finish this bit by saying that I think we work with all of your organizations. These are the opportunities for using your ethics consult process. So that varies a little from organization to organization, but I think we support all of your organizations. We're happy to work with you and your teams as you are making these really significant, challenging decisions. So look, a couple of minutes, please. Comments, hands up. Look, you know what? By all means, read Stephen's comment in the chat. This is the hard work. This is exactly where we're living. It is. I think it's really hard. It could be that any particular individual could say that my sense of myself, my sense of personal dignity, is way more important to me than physical harm. That I can cope with the physical harm because that's just my body. But if I lose my dignity, I've lost myself. And how does that play out? What's the responsibility that places on my family? How does that work in the context of professional healthcare providers who've got the Patient Restraints Minimization Act to follow? You can see the tensions there. So, comments or questions? You're a quiet bunch. I hope the quiet is caused because you're all busily thinking. So look, we're a couple of minutes early. Thank you for coming out. I should just pitch again that we'll be running the Getting Below the Surface series, the sort of intro to health ethics. We'll be running that again, probably April. So look for that. That's 4 sessions that sort of follow on from each other. And we will send the announcement out for those soon. Now just a minute before you go, I need to do this one, don't I? So there's an evaluation with a QR code there, or if you want certificates of participation, those are the places to go to get them. I'll leave those up. And thanks to all of you for coming out.